Hi, Ms. Murphy. I've been working on our client cutting edge computer repair Inc. If you'll recall, you met with them and went over all the information that Mr. Harris and Mrs. Lund had to incorporate their business in the state of Tennessee and to get authority to open a business later in the year in the state of Georgia. So we have put together the initial incorporation documents for incorporation, and they have been in and signed what they needed to sign, and I'm putting it together to send out to them for them to put in their corporate book. But before I did, I wanted to kind of go over with you what I've put together. If you'll remember, these are our clients. I put together a folder with information, and so I just thought I would start by kind of going over the bylaws. I'll tell you what. Let's start with going over the articles of incorporation, and these have already been filed. They were filed on July 21 with the Tennessee Secretary of State. As you can see, we used the form for the Secretary of State, and for ease, when you're going and look at this, I have connected a hyperlink to each of the documents, and I'll point those out as we go through. But the name of the corporation is Cutting Edge Computer Repair Inc. So the Inc. Shows that they did intend it to be a corporation. You are serving as the initial incorporator as we put together the articles of incorporation. And in the very beginning, we checked to make sure the name was available, and we wanted to go in and get this document filed without having to do a reservation of name. We chose that the fiscal year, the company would operate under a fiscal year, with the closing month to be in June, and it will be a perpetual corporation with 10,000 shares of stock. The corporation's principal executive office will be 123 Main Street here in Memphis, and we've used Brad's email address as he will serve as Secretary Treasurer of the corporation. Here we have the firm address as you are the initial incorporator, along with your signature. So we do have this ready for them to put into their corporate book. In line with that, we went ahead and prepared the bylaws, and I will pull those up now. At the very top of the form, embedded in a header, I put a link to the form bylaws that we used, so you'll see what we used. And then, if you'll notice, there's a link in in the bylaws themselves. And clicking on that, I'm not going to do it because it'll take us out of screen, but you can see that this takes us into the Justia Title 48 of the Tennessee Code Annotated, which is the statutes that cover for-profit business corporations. So I'll just look through these again. I put links in all of these for you, and if you just hover over it, it should show you where the links are that we used to fill in the bylaws. Of course, offices relates back to the code at 48-12-102, and since we're doing business in the Tennessee, the Tennessee statutes require that we do have an office within the state of Tennessee, and we can also have offices that are not in the state of Tennessee, and as I mentioned earlier, we will be establishing an office for them, or they will be establishing an office in the state of Georgia. The shareholders meeting, they understand they're to have an annual meeting in which to elect the board of directors. We've explained to them, and we have reminded them in the cover letter that we'll get to, that we put together, that they need to go on and get this done now, just so they can get their officers elected, or named, and get what they need to get done. But this is the statute that covers the annual meeting. They they can have special called meetings. We set that up at there. They should have at least 10% of all the votes if they want to have any special called meetings. All their meetings can be wherever in Tennessee, not in Tennessee. We left that open for them since they will have other offices. Their notice, we did cover their notice of meetings as well as waiver of any notice. The notice, they have to give at least 10 days notice to those entitled to notice, no more than 2 months notice. But they can, a shareholder can waive notice under the provisions of the bylaws. That they are required to keep a shareholders list and be able to show who got notice, how they got notice, and of any meetings or any business that's taken care of. And that's covered under the Tennessee Business Corporation Act. But they shall make that list available at the meetings, so that and make those available if that is called upon, if they're called upon for somebody to review those documents, or a shareholder to review those documents. The shares are all shares are entitled to a vote. And they can be counted together collectively, called a voting group. They must have a quorum, and that hyperlink is here to the section of the code 48.17.208 that defines a quorum being a majority of the votes entitled to cast. And in the event there is not a quorum and they have to call for an adjournment, the bylaws provide for the notice that there was not a quorum present, so any business that was to be transacted at the meeting could not be, because there was not a quorum. Voting of shares, this talks about how that each outstanding shares is entitled to a vote on the matters at the shareholders meeting, and only shares are entitled to vote. In the event a shareholder cannot be at the meeting in person, he or she can appoint a proxy and provide a proxy for their vote, and the guidelines tell how to do that. And this tells that that any shareholder documents, for instance, if a proxy is presented, then the corporation is entitled to accept that shareholder document as being a true an exact document, as long as it matches up with the records that the person executing the proxy is the person who owns the proxy, and they're acting in good faith that this is the right document. Any action without a meeting can happen, as long as there is consent. If the shareholders consent to taking action without a meeting, and it must be done in writing, and the statute governs that. And again, you should be able to, hopefully, hover over that, and all you'd have to do is click on that, and it will take you to Title 48, Chapter 17, Part 1, and 104 talks about actions without meetings. The presiding officer should be the chair, or if there's not a chair, in this instance, they elected to have a president and a secretary treasurer, so their meetings would be presided over by the president, and the secretary would be there to take minutes in the event something were to happen. The secretary couldn't be there. Those present do have the authority to name someone to take the minutes, as those are an absolute necessity. The directors, their powers and duties are set forth by statute. They have elected to their initial bylaws to have no fewer than 2 and no more than 5 on the board of directors. They are initially serving as the board of directors, and we let them know, as well as covering again in the cover letter, that these bylaws can be amended under according to statutes, and that they can add up to 5 as this goes. However, that can be amended as well. The directors will serve for a year, and then they serve until the next board of directors. The board of directors will hold regular and scheduled meetings, and they are required to give notice of these meetings. They can do it in person, or they can do it email, however they do it. But at the same time, they have the same requirements. If they adjourn any meetings, notice was required unless they consent to not have any. The consent to not having a meeting or notice is not required. We define what a quorum is, and that is determined by the number of the board of directors. So if it's a majority of the board of directors, so again, that would be determined by how many are on the board of directors. This talks about voting, that an affirmative vote of the majority of the directors, unless the bylaws require otherwise. That should be that is an affirmative vote. And this talks about actions without a meeting, that they have to be done in written consent. It's signed by each director, and indicating the director's vote, or if they decided to abstain. And again, everything must be kept. All the notes and minutes from these meetings must be kept. And we're going to suggest in the corporate book, so that they can, or at least the notice in there to where they can get to their records. I don't know what they have not told me yet what they're going to do about compensation, but they have allowed for compensation in their bylaws. And of course, if there is any of the officers or board of directors has the right to resign. If there is a vacancy, the other directors, as well as in the course of a resignation, they can appoint someone to fill that spot until such time that they have a meeting to re-elect a board of directors. Of course, the directors can be removed if the shareholders decide they want to do that. They have to do it by voting, but they can, or the directors themselves can remove someone on the board of directors. This has to be done at a meeting that's called specifically for that purpose. It must be named at that meeting that's what the intent is. This talks about Article 4 talks about the creation of committees, and that is allowed by the board of directors. The officers, again, as I mentioned earlier, right now it's going to be a president, secretary, treasurer, but we leave it open that they can amend that if and when they decide to do that. The officers are appointed by the board of directors annually. And again, and the officers shall serve at the pleasure of the board of directors until a successor has been appointed. Officers have the same rights for resignation, or they may be removed and any vacancies filled for the term by the board of directors. The duties, and again here if you look, we have the hyperlink in here to 48 18402, and again this is I haven't clicked on every hyperlink, but each one of these divisions in the bylaws is connected, is linked to the coordinating statute in Tennessee's code. But we will have a president. Talks about the duties of the president. In this instance, we don't have a vice president. We left that paragraph in there in case they want to add one. They can, but we did the secretary treasurer. It will be the president, the secretary treasurer in this instance, and of course the secretary treasurer as a combined I guess office will be responsible not only for keeping all the minutes, maintaining all the stock certificates, keeping up with all the records, but will also be the chief financial officer, keeping up with all bank accounts, all those things for the corporation. Here we left it open for for other officers and for any delegation of duties should the necessity arise. The corporation it will indemnify any of its officers or its directors from any loss or lawsuit. And this is allowed under the code, under Title 48, Chapter 18, Part 5, where the officers and board of directors are indemnified, and the company does have right to advance any expenses in the event one of the officers was to be sued. The company can cover legal expenses or other expenses necessary, and also purchase insurance to cover the officers in the event they were to be sued. So that is covered by the statute. As far as shares of stock, the shares can be issued with or without certificates. They have elected to issue with certificates to begin. They'll issue those shares of stock based on, they'll make sure that they're completed as they should be, with names and addresses and whatever classes that they electively choose. They'll be signed by the president and by the secretary, in this instance the secretary treasurer. In the event they have shares without certificates, then say for instance if somebody they were going to issue shares to somebody who wasn't here to hand off the certificates they can do that. They'll maintain it in the stock ledger, but they must give that person under the statute. If that person comes and asks for a certificate, they must give them a certificate. And any subscriptions for shares must be in writing. Anybody that they intend to give any stock in the company to, that has to be in writing. Any transfers can be done, but it must be maintained through the books of the company. The transfers must be done by the holder of the record, and then they have to be, or by power of attorney, and they should be properly endorsed, and any taxes paid, that's all on the duty of the holder of the certificates. In the event of lost certificates under the statute, the company is required to replace those certificates, but only once it has been assured, and usually by affidavit, that those certificates are lost. They will cancel the outstanding certificates and reissue certificates based on the statute under 47.8.401, which is the securities part of the statute as opposed to the corporate title in the statute. But Chapter 47 covers securities, and so I wanted to bring attention to the fact that that is covered under a separate chapter in the code. Corporate actions, if you'll notice, the hyperlink is here under the article, as corporate actions are covered in Title 48 under 18.402, and it's the board of directors can set forth, or the board of directors, or the bylaws, can set forth who is entitled to do what. Who can cash checks, who can they can do this specific or general, and generally would be done by resolution at a meeting. At the initial meetings, they would establish who can open bank accounts, who can sign checks, but it can be general or confined to specific business, and if so, 2 or more of the officers may be required. So, but they will determine those things, where their deposit's going to go, any voting securities that the president shall have power over, and they will determine all of these things once they have their first meetings and go according to these guidelines, determine who, or these bylaws, who will what authorities they will have. The dividends, the board of directors may declare to pay dividends. It doesn't say they're required to, but they may. They'll record the date of the determination of the shareholders who's entitled to receive payment, and they have to give notice of any dividends. As we mentioned earlier in the incorporation document, they have elected to be the June June will be the fiscal year for the company. And now that I'm here and saying that, I need to look at the charter. Let me do that right now while I'm here and see. This says that the fiscal year of the corporation begins on the 1st of June, and it seems like we had that the fiscal year close month will be June. So what I'm going to do while I'm here, since the incorporation statute, since the articles say June, we need to make our bylaws match those. So I'm just going to do that while I'm here. Let me open that back up, and we're going to make our fiscal year begins on the first day of July each year and ends at midnight on the 30th, as June only has 30 days, 30th day of June the following year. So we will make, I'm making that change now since I caught that. The corporation will not have a corporate seal. We can amend the bylaws as needed to be, and with affirmative vote of the majority of the shares represented. And then notice is covered. The notice provision of the statute, which is chapter, which is 48.11.202, encompasses notice provisions, and we've recaptured that here in Article 11. as far as notice where it is all concerned. And as Mr. Harris has already signed this, I will get him to, I'll get him to come in and we'll re-execute this document before I send it out to them under the cover letter. And since we did make a change, I'll get him to re-execute the bylaws, and then we'll send them out under the cover letter. So we have also drafted a Georgia an application. It's an application for certificate of authority for a profit corporation in the state of Georgia. Here's a hyperlink to the Secretary of State's form there. We use Cindy's email address here, and Cutting Edge, the name of the corporation, will commence business in the state of Georgia on September 1. We will remind them in the cover letter, we are reminding them in the cover letter, to do not begin to conduct business in the state prior to September 1. The statutes frown on that. So Brad is actually submitting this form as Secretary of Treasurer on behalf of the corporation. Since the charter's already been filed, and they've just naming him as Secretary Treasurer, he has executed this document. But now that I'm seeing this, we need to have him appointed by a meeting of the board of directors before we do this. So I'm going to go on in here and we will have him also re-execute this document once there is a resolution that names him Secretary Treasurer at a properly held meeting. We will do that, but this is a profit corporation in the state of Georgia. We named the registered agent Mr. Abrahams, and used our Atlanta address as the registered agent in Georgia, but we have listed Cynthia and Bradley as President, Secretary, Treasurer, which will be what they will be once they are appointed by under the Tennessee bylaws. So there's our certificate of authority in the state of Georgia. And then we have, I'm just going to go back here and pick up here and get our cover letter. I've just drafted to them, of course, thanking them for allowing us to work with them on setting up their corporation. Explain to them that we're including the articles of incorporation, which show they are authorized to do business in the state of Tennessee, and it has been filed. This will be correct because I'm going to get Mr. Harris back in to sign. We'll sign the bylaws. Not sure how we're going to do that. We'll need them to have a meeting. Well, they'll be able to have a meeting, so he'll sign the bylaws as Secretary Treasurer. And we've gone through I've gone through what each of the what the bylaws do for them. That the bylaws are their guidelines on how the corporation will operate, and I've gone through just a general overview of what the bylaws do for them in the cover letter, which you've gone over with them as well. So this is just a reiteration of what which you've already gone over them, but we're reminding them that they need to familiarize themselves with these bylaws, maintain them in the corporate book, along with any amendments thereto. We'll include the certificate of authority to do in the state of Georgia, because we'll go on and file that, showing that they're not going to begin business until September 1. So we put this letter together for you. I think we have the packet once we get Bradley back in to execute those bylaws. Since we made that one change about the fiscal year, I think we will have this packet all ready to go to the client. That's everything that we have. And again, it is the it is the full packet, and we will include for them the bylaws. We will include the articles of incorporation, the charter, or the certificate to do business in Georgia, along with the cover letter. So I think we're good to go, and the link should be operate for you. Thanks.